weekly, well, week and a halfly um, video lecture in response to your blog questions and in anticipation of the test, which will go out tomorrow, Thursday at noon. Keep in mind you'll have until Friday noon to finish and send in your answers. You don't need to include the questions. There will be more specific instructions in the test instrument itself about how to send it back to me. If once you get the test, you're reading the question and something doesn't make sense to you, email me at proflovingblogs@yahoo.com. If it's something I can clarify for you, that's fine. But on the other hand, if my answer to your question gives you the correct answer to the question, then I won't be able to speak to that. I'll be checking my email roughly every hour except for those hours when I'm asleep. So let's get on to some of your questions from the blogs. A couple of you had questions about the Oklahoma City bombing. One question was, why did the government pay for McVeigh's defense team? We'll cover this in the Free Press Fair Trial section, but the Sixth Amendment guarantees defendants a right to a fair trial, and it's not really fair if the government has a lawyer but the defendant does not have an attorney of her own. So in the case of Gideon versus Wainwright, the Supreme Court held that defendants who did not have enough money to pay for their own lawyers were entitled to an attorney paid for by the state. It was a guarantee of fairness in criminal justice, and nobody else was going to step up and do it. So Gideon versus Wainwright is the subject of a book, Gideon's Trumpet, by Anthony Lewis. The book was made into a movie, and if you have some free time, I recommend both. If you don't have a whole lot of time, I recommend the movie because it's not bad. But it's one of those, the Miranda warning, if you do not have an attorney and can't afford one will be appointed for you. That's what happened. And McVeigh and Ed Nichols, his co-defendant, didn't have a whole lot of money. And for a case as big as it was, they had, if I recall correctly, 6 to 8 attorneys working on the team, and that didn't even include all the support staff. So McVeigh and Nichols couldn't have paid for their own attorneys, so they got court-appointed attorneys. Another Oklahoma City bombing question asking why it would have been unfair to McVeigh's fair trial rights if his confession was published. And follow-up question, should the jury have the right to every piece of information in order to render judgment? Well, the answer to that is if people read McVeigh's confession, they would likely come to a conclusion about his guilt because, after all, he does tell his lawyers how he set the fuses and walked away from the truck that was going to blow up in a few minutes. If people had read his confession, then they might not be able to serve on his jury because they, having read the confession, would approach the case with a conclusion about his guilt or innocence. Now, McVeigh's fair trial rights are the responsibility of the judge, not the journalist. The judge would have been the one to impose a prior restraint on Playboy if he had found out about the article beforehand. So, going into this a little more, juries who decide cases are only supposed to decide cases on the basis of evidence that is produced from the witness box. That evidence has gone through an examination. Sometimes there have been fights over whether it should be admitted or not. Ultimately, the judge decides if evidence should be admitted because its value to the jury outweighs any risk of prejudice or other untoward effect toward the defendant's Sixth Amendment rights. So, evidence from the jury box is the only evidence that's considered to be reliable enough to be admitted in court. So, if the jury could read the McVeigh confession, they wouldn't be able to put that out of their minds. And when they went into the jury room to deliberate, that would influence their decision. The other thing to be concerned about is sometimes what the jury can read and hear is not going to be correct. And when we get into Free Press Fair Trial, we're going to see some cases in which the criminal defendant just really had the deck stacked against him because of all the incorrect and inflammatory reporting in the media. Sixth Amendment rights must be guaranteed. The judge is the responsible party. The judge is also responsible for ensuring that the evidence that gets before the jury is reliable, but we'll cover that more in the Free Press Fair Trial chapter. I will point out that the jury, in fact, got to hear something related to McVeigh's confession. Part of the bond consisted of canisters of nitromethane fuel. Nitromethane fuel is a fuel that is used in race cars. You can't just go down to the gas station and get it. And in his statement to his lawyers about what happened, McVeigh talked about going down to the North Texas Speedway, just north of the Dallas-Fort Worth Metroplex, and buying the fuel. So the FBI went to the North Texas Speedway, had a photo lineup, and interviewed a bunch of folks, and one guy said, yes, I remember this guy. He bought cans of nitromethane fuel from me. That person from the North Texas Speedway was a witness for the government. In fact, it was pretty strong evidence because he remembered McVeigh, remembered what he bought. So ultimately, the jury did get the benefit of McVeigh's, quote, confession. Remember when I talked about trying to figure out a way to publish the story in Playboy without Judge Mates, the presiding judge, issuing a prior restraint? Well, I said that we had hoped that the judge would sequester the jury once he picked it, but he didn't. So one of you had to question, what is sequestration? It's one of the tools that judges are supposed to use to keep juries pure and unsullied by information that hasn't passed the test of reliability used for the witness box. And what it essentially is locking up the jury. The members of the jury wind up living in a motel, sharing rooms. They're not allowed to read newspapers, magazines, unless the newspapers and magazines have been examined by bailiffs who will cut out articles that might relate to the case. They can't watch TV unless the bailiff is controlling the remote control, because the bailiff will have to turn off the TV if there is a news report or a news bulletin related to the case. Jurors are not allowed to listen to the radio. They're not allowed to use social media. So the reason for that is, if a juror reads a story in the paper about the case, or the juror hears a radio commentator, or the juror looks at social media on Facebook and everybody's saying, oh, this guy obviously is guilty, then it might influence the juror when it comes time to deliberate. That would be wrong, and it could deny the defendant her right to a fair trial. So sequestration, you lock up the jury to keep them from being tainted by prejudicial information. A question related to prior restraint and the McVeigh case and the WikiLeaks about why journalists don't just put everything online to avoid having a judge issue a prior restraint. Well, if you've done an internship or you have a job, you'll know that you're expected to post things on social media all day long in order to draw a bigger audience. But we don't post the story online until it's finished. Sometimes a journalist will not be finished with a story when one of the people he interviews or somebody who's subject to the story finds out about the reporting and goes to the judge to ask for a prior restraint. It can be as bad as having a prior restraint to try to put up a story that still has holes in it, because the ultimate truth isn't known until we finish the process of reporting. So yes, we do a lot of this posting online, but we, again, don't post unless the story is ready to go. Question about hate speech. And can you use the law to restrict hate speech? The problem with trying to come up with a law that restricts hate speech is that it pretty much is not possible to write a law that would be constitutional. To begin with, the law is going to be under-inclusive unless you pick all possible targets of hate speech. If you only pick some words and symbols that affect certain groups, then you're only protecting that group. You're giving preferential and unequal protection. and we're supposed to have equal protection under the law. So imagine trying to come up with every word or symbol that would offend or anger or cause someone anxiety, and link that to whatever group the word or symbol is associated with. You'd have a law that would be 100,000 pages long. Then we have the other part of the problem with trying to legislate away hate speech. Whatever words or symbols that are hateful that you try to outlaw, well, there's likely to be a positive use for the word or the symbol. For example, burning crosses. In the 1990s, Eyes on the Prize was a popular course on many university campuses. It was about the civil rights movement. And as part of the series, they showed Klan rallies, which included burning crosses. So the people teaching the class Eyes on the Prize could well be sanctioned if there was a law saying you can't have a burning cross. Nazi symbols used in war movies all the time. So they have a positive use. Here we're talking about over breath, just as in the Stevens case. When your law catches in its net both positive and negative uses of the word or symbol, it's too broad because it opens the door to punishment for people who don't intend to do bad things. Now, you might sit down and say, well, what if we write this law, we've identified all the symbols and words, but we'll make it so that if someone is charged with a crime of using the hateful symbol or word, that person can defend him or herself by testifying that the use of the symbol or word was not for a negative purpose. So that's going to be an issue of proof, and people will swear up and down that they were pure and innocent as the driven snow, when in fact, in reality, they were mean as, well, being mean. A final note is that if you write a law that punishes particular speech, it can have what we call a chilling effect. The law could chill speech. And what that means is some people who might use the word or symbol would not use the words even in a positive manner because they would be worried that they'd be prosecuted and might be punished. So they just shut up entirely. In the first part of the book, when we talk about philosophies, we mention a couple of things about chilling speech. And chilling speech is people censoring themselves because of some government rule. Also, can we make wearing blackface illegal? You could make wearing blackface illegal, but then the law would be challenged on the grounds laid out in the previous slides. It would be under-inclusive, it would be overbroad, so it wouldn't work. A couple of you brought up the issue of free speech boards on campus versus people who wanted to hand out flyers in the dorms. Remember that the free speech boards on campus are public forums. The dorms are not public forums. The dorms are, at best, limited purpose public forums and so can restrict topics and advertising and speakers. Here, relating to forums, the question is, well, the military police went out and told Mr. Flower that he couldn't protest on New Braunfels Avenue. Doesn't that mean that the government was enforcing its right to ban speech? In the case of Flower versus United States, it was too late. Civilians had been using the avenue for decades. At no point was there a restriction as to the content of speech or the speakers on the road. So, because it was too late, because too much free speech has occurred, the government is careful to keep people from engaging in expression on government property that is a non-public forum. I grew up in the military, And the military used to have Armed Forces Day, where people could come on to a military post or base, and there'd be demonstrations to show folks how the Department of Defense was spending all the tax dollars, and to give people encouragement as to how ready the military was to defend the country. There were special rules that the post commanders had to follow to ensure that whatever demonstrations were given were strictly in line with demonstrating the ability of the armed forces, and that no other topics could be covered during Armed Forces Day. That's because they were afraid if they allowed the other topics not directly related to the military, they might be opening up the military base to becoming a limited purpose forum or even a public forum. Last question here: how long does the government have to be inactive before a non-public forum becomes a public forum? And the answer is it depends. It's going to be based upon the circumstances. The courts will look at the nature of the forum, then it will look at who's been allowed to speak, what restrictions on speech have existed. Here in this other slide. So if somebody sneaks onto government property after midnight, holds up a protest sign, waves it around, that doesn't change the nature of the forum from non-public to public. The speech activity needs to be out in the open. It needs to be, if not continuous, then regular. And a single protester waving a single sign at 2 o'clock in the morning will not change the nature of a forum. How does the government decide what it will allow in limited purpose public forums? Well, somebody makes the decision. And it's people in government. So if you're a city and you have a city bus line, you're going to sit down and decide whether or not you're going to allow advertising on the side of the bus, and which advertising and by whom you will allow to advertise. Now, there's a lot of discretion, but it's not unlimited. The government cannot be arbitrary and capricious in its choices. So, for example, if the government said only brown-eyed people could advertise their products, it would be an unconstitutional application of government power. Question about more forums. Resist protesters. There's a march after the election of Donald Trump, and protesters in slow pretty much fill up a street as they go back and forth. And the question is, would they need permission from the city? They probably would need permission from the city, because most governments have in place mechanisms whereby they enforce and exercise their police powers. So SLO would likely use its police powers to require protesters to get a permit, and that would be constitutional because of concerns about public safety and the free flow of commerce. In fact, the city could probably institute a number of requirements before allowing the protests to take place, as long as they were reasonable under the circumstances and related to concerns about public safety, public health, public welfare, and the free flow of commerce. Okay, Reverend Bob, he comes to campus, tells you all that you're going to hell because of the things that you do. How does he get to do that? Well, the campus has spaces that are public forums. And if it's a public forum, then any speaker has the right to speak on any subject. Now, the speakers, even in a public forum, must still follow laws of general applicability by not inciting violence or committing other crimes. If someone is harmed by a speaker, that person has the right to sue the speaker for the harm caused, and that would be a straightforward civil suit for damages. Okay, so things that happen this past academic year. Speaker gets invited to a place, and then there's a cancellation because of protests. And the question is this an infringement of First and Fifth Amendment rights? It might be, but it's not likely, because state action is required for the infringement of constitutional rights. it's not the state which invited the speaker who is now preventing the speaker from appearing. If you invite somebody, you can withdraw the invitation. That's not a violation of First Amendment rights. Now, people criticize the protesters who shut down speeches, and they do so because the protesters are not allowing divergent points of view. And that's kind of an interesting thing. And we have to be careful about that. I mean, we know, of course, that we are completely correct in everything upon which we have an opinion. But remember, the marketplace of ideas says that all ideas should be allowed in the marketplace, and the truth will win out. It will be the thing that people recognize. And with respect to the speakers who have different points of view, seeing a false idea can help us understand the truth of the real idea and reinforce our belief that it is the true and correct idea. Enforced silence means, well, basically, and it's been said in court cases, that people are afraid of the competition. So, if you want, we can bring up some of the cases that make that argument, cases from the Supreme Court. Question in the text, I make reference to the AIPAC case, the America-Israel Political Action Committee. And the question is, how is this a model for prosecuting journalists? Because the charges against the AIPAC guys were dismissed. Well, the charges were dismissed, but it took a very long time for that to happen. But here's the model for prosecuting journalists. The AIPAC guys were charged with violating the Espionage Act because they were in possession of classified materials. Journalists get classified materials on a fairly regular basis. The Pentagon Papers was about a classified history of American involvement in Vietnam. The NSA leaks, they're spying on us. Well, that included classified material. And leaks from the White House, the Trump White House. If a reporter gets leaked national security information from the Trump White House, that reporter could be at risk for prosecution under the Espionage Act. That's how AIPAC became the model. It dealt with people getting classified material and then being arrested and charged with violating the Espionage Act. Question about property rights and curtilage. And there you can see the spelling of curtilage. So if a grumpy old man, or story that was in the news recently, police officer not being happy that a couple of teens have to be on his lawn, shooed some kids away, could he still have them charged with trespassing? And then what about people on your front porch? We'll cover trespass in part 2 of the class, but for now understand that curtilage is a long-standing practice through usage and custom. Parenthetically, the phrasing is important because it justifies allowing people to walk across your lawns, kids run across the lawn, meter readers, letter carriers, package delivery people across people's property, and it's not a big deal. But if the grumpy old man comes out and says, "Get the hell off my lawn," he's revoking the kids' right to be there. Now, if they leave, he has no complaint. But if they don't leave in a reasonable time, he could call the cops and make a trespass complaint and also file a trespass claim in civil court against them. The front porch. Front porch, pretty much the same thing. It is the porch, but unless it's an enclosed porch, unless there's some physical delineation that shows it's separate from the yard and the sidewalk, it'll be treated as the curtilage. You can put up a notice saying, "Don't ring my doorbell," or "Get the hell off my porch," or you can tell people through the door or the window, "Get the hell off my porch." At that point, you've destroyed their consent to be on the property, and they have to leave or they will be trespassing. Incitement. Well, incitement usually is not considered to be criminal speech. Criminal speech is speech that is used to commit a crime or that aids and abets the commission of a crime. So criminal speech used to commit a crime is quote, I have a gun, give me all the money in the cash register, that's criminal speech. You're using speech to carry out a crime. So incitement is trying to get somebody else to carry out a crime. It's not necessarily going to come into play. Incitement speech is not often criminal speech. In fact, I can't offhand think of any cases where incitement was charged as criminal speech. And then, also related to incitement, is it a three-part test? The second bullet point has the definition for incitement. So we see that there's more than three parts. Number one, words directed. So that's expression by a speaker. Number two, intended to cause listeners. Well, intent is a key element in incitement and is one of the ways a lot of people who are sued for incitement can defend themselves. I made a movie, but no, I didn't intend that people copy my movie and do dumb things. Third element, cause listeners to commit specific criminal acts. This goes to what was done compared with what was said, and that are likely to produce the violent acts. Here, this test goes to whether or not the words either led to a criminal act or would be interpreted by a court as being likely to lead to the act. So, 4 parts, but it's not so rigid as to require that somebody said something with the intent to cause somebody else to do something. That person, in fact, did the specific thing, and because they did the thing, then it was likely to produce the violent act. So here's the thing. We don't always need to have the criminal act as a result of incitement. Courts can conclude that a criminal act would likely result from the words. And here's an example. Remember the Skokie March by the Nazis. During the Skokie controversy, a press conference was held in California, and a speaker in front of news cameras held up $100 bills and offered to pay $500 to anybody who brought him the ear of a Nazi. This offer is not in effect. It's not a real offer. He was charged with incitement. Now, he spoke words. He had the intent to cause a crime, cutting off the ear of a Nazi. The courts didn't require that somebody actually go out and cut off a Nazi's ear to be able to charge him and convict him of incitement, because the courts interpret the clear language they offer as posing a real risk for such an attack to take place. And that is the end of the blog questions you have. I'll be sending the test out in some hours. Good luck, and just kind of take your time. Be sure you understand the questions. And I'll see your tests in a couple of days.